Welcome to literary and jury charge practice. Let's start out with some jury charge. Ready? Here we go. The works "Got to Give It Up" and "After the Dance" involved in this trial are known as musical works or musical compositions. You are instructed that a copyright may be obtained in the musical compositions "Got to Give It Up" and "After the Dance." These works can be protected by the copyright law. Only that part of the works comprised of original works of authorship fixed in any tangible form of expression from which it can be perceived, reproduced, or otherwise communicated, either directly or with the aid of a machine or device, is protected by the Copyright Act. Copyright protection for an original work of authorship does not extend to any idea, procedure, process, system, method of operation, concept, principle, or discovery, regardless of the form in which it is described, explained, illustrated, or embodied. Copyright law allows the author of an original work to prevent others from copyrighting the way or form the author used to express the ideas in the author's work. Only the particular expression of an idea can be copyrighted. Copyright law does not give the author the right to prevent others from copying or using the underlying ideas contained in the work, such as any procedures, processes, systems, methods of operation, concepts, principles, or discoveries. The right to exclude others from copying extends only to how the author expressed the ideas in the copyrighted work. The copyright is not violated when someone uses an idea from a copyrighted work, as long as the particular expression of that idea in the work is not copied. Anyone who copies original elements of a copyrighted work during the term of the copyright without the owner's permission infringes the copyright. On the gay parties' copyright infringement claims, the gay parties have the burden of proving both of the following by a preponderance of the evidence. 1. The gay parties are the owners of a valid copyright, and 2. The thick parties copied original elements from the copyrighted work. If you find that the gay parties have proved both of these elements, your verdict should be for the gay parties. If, on the other hand, the gay parties have failed to prove either of these elements, your verdict should be for the thick parties. Instruction number 27 states that the gay parties have the burden of proving that the thick parties copied original elements from the gay parties' copyrighted work. The gay parties may show the thick parties copied from the work by showing by a preponderance of the evidence that the thick parties had access to the gay parties' copyrighted work, and that there are substantial similarities between the thick parties' work and original elements of the gay parties' work. As part of their burden in instruction number 28, the gay parties must show by a preponderance of the evidence that the thick parties had access to the gay parties' work. The thick parties had access to the gay parties' work if the thick parties had a reasonable opportunity to hear the gay parties' work before the thick parties' work was created. Substantial similarity requires similarity of protected expression. Similarity that is confined to ideas and general concepts is not infringing. Similarities derived from the use of common ideas are not protected. In determining whether the gay party's work is substantially similar to the thick party's work, you must not consider in your comparison any ideas as distinguished from the expression of those ideas, elements borrowed from another author or from the public domain, ideas that can only be expressed in one way, so that the idea and its expression merge, expression embodied in the work that flows from a commonplace idea, or expression that is so standard in the treatment of a given idea that it constitutes something that must be done in expressing that idea. Trivial copying is not copyright infringement. Copying is trivial if the average audience would not recognize the copying of the gay party's work in the thick party's work. You must determine whether any copying of the gay party's work in the thick party's work is trivial. If the copying is trivial, then the thick parties did not infringe the gay party's copyright. If you find for the gay parties on the gay party's copyright infringement claim, you must determine the gay party's damages. The gay parties are entitled to recover the actual damages suffered as a result of the infringement. In addition, the gay parties are also entitled to recover any profits of the thick parties attributable to the infringement not taken into account in computing actual damages. The gay parties must prove damages by a preponderance of the evidence. The copyright owner is entitled to recover the actual damages suffered as a result of the infringement. Actual damages means the amount of money adequate to compensate the copyright owner for the reduction of the fair market value of the copyrighted work caused by the infringement. The reduction of the fair market value of the copyrighted work is the amount a willing buyer would have been reasonably required to pay a willing seller at the time of the infringement for the actual use made by the infringer of the copyright owner's work. That amount also could be represented by the lost license fees the copyright owner would have received for the infringer's unauthorized use of the copyright owner's work. Alright, now let's try some literary practice. This is called a hybrid for everybody. Ready? Here we go. The first gasoline-electric hybrid cars that came to the U.S. market were like Star Wars droids, cute and technically interesting, but as practical transport, not so great. Honda and Toyota's early hybrids, the Insight and the Prius, respectively, were small cars with tight cabins and little luggage space. Nor were they particularly pleasing to drive, running as they did on hard-riding narrow tires. Much has changed in hybrid land during the past decade and a half. Today, nearly every major automaker offers the fuel-miserly, planet-friendly technology. Even Porsche recently revealed that the 911, perhaps the most iconic sports car of all time, will likely be hybridized in order to meet even tighter fuel economy and emissions regulations. Today's hybrids come in many forms, including comfy family sedans, oh so popular crossovers, and yes, high-performance supercars. That was a short one, I know. Let's see. Let's finish up an article we had started before about certified pre-owned cars, CPOs. Ready? Here we go. Second, pay for a pre-purchase inspection at a repair shop. AAA approved auto repair facilities in many regions of the country offer them. Because a CPO car should come with a warranty covering mechanical and electrical issues, these things are of less concern than uncovering previous collision damage that could reduce the car's value or make it unsafe. Accidents sometimes go unreported on history reports. Fortunately, California's Car Buyer's Bill of Rights provides protections. It prohibits a car from being sold as certified if its odometer was rolled back, if the title is branded as lemon law buyback or salvage, or if the car has frame damage. Of course, this doesn't always prevent dealers from certifying such cars anyway, but the state's Consumers Legal Remedies Act provides for lawsuits. Bottom line, if the car's price is reasonable and you're under no illusions as to what you're getting, then the CPO designation can be a good value. All right, now let's practice this closing argument. Ready? Here we go. There's also a firearm allegation. In this case, if you find him guilty of either first-degree murder or second-degree murder, you must render a verdict on the special allegation that he personally discharged a firearm causing death or great bodily injury. Now here, there could be no doubt that the defendant killed Sue Reyes by shooting her in the back, so you should fill out that verdict form as true. We are asking you to find him guilty as charged. It's time for him to get what he truly deserves, a verdict of guilty of first-degree murder. I'm going to go into some areas that I think the defense attorney might come up with to rebut. This is kind of a pre-rebuttal in a way. He will probably try to say that there was a burglar who was the real killer, okay? So let's look at some of the evidence that proves there was no burglary. There was no burglar as the real killer. Now, there was a photo of the window screen that was removed from the defendant's house in making it look like maybe there was a burglary. You remember, I'm not going to go digging through them now, but you remember there was a photo that had the window open. That photo was shot July 13th, 2013. But testimony from Sheriff's Crime Scene Specialist Kim Shapiro shows July 9th, during the initial investigation, a photo was taken to show the house with that window intact. Now I expect the defense attorney to bring up this burglar's footprints going back and forth from the house of the chicken coop. Now Detective West testified that he drew a chart. That chart, let me see here. Detective West had a chart that he drew, a diagram here. It is Exhibit 40. And on placard 6, this area, there were some footprints going back and forth between the main house and the old barn. The defense is probably going to say that that was the real killer's footprints. However, if you look at the photos people testified to, there was testimony that exhibit placard 6 photos. We have Exhibit 56. This was the alleged real killer's footprint of this Exhibit 56. There was also Exhibit 55, which was placard 7, but the testimony was that the firefighters there were asked to stand off to the side. Then photos were taken of their footprints, their foot impression, and you saw the photos. Exhibit 57 right there, Exhibit 58, placard C right there, placard D, Exhibit 59 right there, E, Exhibit 60, and you can look at all these photos when you get back to the jury room. You'll see that the firefighter photos are similar to, if not exactly identical, to the impression made by the footprint in Exhibit 7, placard 6, So, in fact, Detective Taryn will testify from the stipulation that the judge read to you that just before we started closing arguments here, the following: if Sergeant Taryn was called to testify as a witness, he would testify that some shoe tracks were pointed out to him leading from east or towards the outbuilding. He looked at those shoe impressions, and together with others, they felt they were consistent with the impressions of the responding fire department personnel. So the so-called real killer's footprint was just a firefighter paramedic. What about the tire impression? Defense attorney is trying to argue that the curving tire tracks shown in placards 3 and 4, Exhibit 71 and 72, might be arguing that those were the real killers, right? Well, it's true that tire impressions there, Exhibit 78, 73, and 74, don't match up to here's one of them. Exhibit 73 is a tire impression that barely has anything. But the defendant's vehicle, the defense will probably argue that the curving tire tracks shown in placards 3 and 4 do not correspond with either of the victim's or defendant's vehicle. They might be tire impressions belonging to the burglar. And it's true, the tire impressions in number 5 don't match either car. Now, Carol Foster, the crime scene specialist that photographed the defendant's SUV, said that the tires were bald, and bald tires leave no tread, just like the photos in 73. What about the tire impressions that had kind of squiggly lines? There were some tire impressions that had squiggly lines on them. There were tire impressions there. We will find them soon of some with squiggly lines, all right? But if you'll remember, Sergeant Taryn remembered that the defendant and George Maxey were riding around in a golf cart on July 9th, 2012. I did a misprint, wrote 2015. Sure enough, photographs of that golf cart were taken. From a distance, you can't see much, but as you get closer, you can see that the tires from the golf cart are squiggly and match the tread in exhibits 71 and 72. In fact, let me put, here's the exhibit of the tire. That was where the tire tracks were kind of in a curving area and kind of an arc in front of the residence. But if you look at the photos of the golf cart, if you look very closely, you'll see that this exhibit 89, you'll see that these tire tracks have kind of squiggly lines. All right, that will conclude our literary and jury charge practice.